Hey everyone, welcome back to my channel. My name is Meenakshi and I am doing a video series on Indian Penal Code. So in today's video, we are going to discuss a question from 2012 December KSLU question paper. As you can see, the question is write a short note on theft. So this question was for 6 marks I guess, but because the maximum marks that you would have for one question is 16, so I would suggest that whatever question you are preparing for, you should try to prepare it for 16 marks. So accordingly, this one also I am going to show you an answer which would be sufficient for 16 marks as well. In case the question is for 5 or 6 marks, you can obviously narrow down your question, narrow down your answer, right? You can skip some of the parts which are not so important, and then you can focus on only the relevant points, and then you can write the answer accordingly. Now whatever the question is, whether it's a short note or they are asking you like a subjective type question, it's always a better idea that we start with an introduction, because even if it's a short note, it's not a question for 2 or 3 marks, right? It's for 6 marks and you need to write at least this much, right? At least 2.5 pages or something like that, even if it's a short note question. So I would suggest that you can start with a basic intro on the topic, and then you can come to the topic and then explain what they are asking you, right? Like a short note on theft, you can explain the detailed provisions with regard to theft. So let's see how we can answer for this question. So for the intro, you can mention that the offense of theft is mentioned under Chapter 17 of the Indian Penal Code, and it is coming under offenses against property. Then property is one of the most important constituents of human life, and because we want to protect this right to property, we have all these different laws coming in, right? All these different provisions mentioned under Chapter 17 of IPC are because we want to protect whatever property we hold or we have acquired. Then you can mention that there can be 2 different types of properties, movable as well as immovable properties. And under Chapter 17, IPC has made provisions both with regard to movable as well as immovable properties. And all those different offences as well as punishment for the same are mentioned under Chapter 17 of IPC, sections 378 to sections 460. Once we are done with a basic introduction, we can come to theft. What is theft and what are the provisions specifically mentioning regarding theft? So what are offenses against property? It's basically something where a person is deprived of his property, right? If someone commits a wrong whereby that person deprives me of the property that I own, it's a theft or it's an offense against property, right? So you can mention that. Then you can specify that sections 378 to sections 382 specifically provides for the offense of theft and the provisions relating to it. After that, you can explain what is theft. You can either go for the definition of direct if you prefer that, or otherwise you can write it in your own words also. So I have tried to simplify the definition of theft. What is theft basically? When someone moves a movable property out of possession of a possessor, alright, it's not an owner but a possessor who is having possession of the property at the moment, with a dishonest intention of taking such property without the consent of the possessor. It will be considered as the offense of theft. For example, if A cuts down a tree which is attached to Jed's ground with an intention that he will take possession of that property or he will move that tree from Jed's place, in that case it would be considered as theft. Once you have explained what the offense of theft is all about, we can come to the ingredients. What are the essential ingredients that we need to satisfy for the offense of theft? So the first ingredients which we have is dishonest intention. Yes, the property must be moved. A movable property must be moved out of possession of a possessor. But there should be an evil intention. There should be a bad intention, and with that intention only I should move the property. So first essential that we have is guilty intention or bad intention or dishonest intention. Take for example, we both are classmates, alright, we are in the same class, and one day you carried your laptop to the classroom. But you left and you forgot to carry your laptop along. Alright, being your friend, I saw that your laptop is there in the classroom and I thought that maybe someone may just take it or it may get damaged or lost or something. So I carried it with me, but I was not having any dishonest intention. Alright, I thought that tomorrow I will return the laptop to you. But maybe I was not having your phone number, so I could not inform you that I am carrying your laptop with me. Alright, so in that case, I am not guilty of the offense of theft. Even though I moved your movable property, right? Laptop is a movable property. I moved it without your consent, without your permission, or without your knowledge. But even in that case, I will not be guilty of theft. Why? Because I was not having any guilty intention, right? So that is the first essential ingredient, that is dishonest intention must be present. The second essential ingredient which we need is that property should be a movable property. What is movable property? Movable property is anything except land or anything which is attached to the ground or permanently fastened to something which is attached to the ground. So other than that, all the other properties which we hold or which we have are considered as a movable property. So what about a tree? Is tree a movable property or an immovable property? Trees can be a movable property the moment it is separated from the ground. Alright, trees will be attached to the ground, but if I have a guilty intention or a dishonest intention and with that intention I cut down the tree, the moment it is separated from the ground, right, it becomes a movable property. And the mere fact of separating it from the ground would itself constitute the offense of theft. So second ingredient is that the property must be a movable property. Third thing that we need to satisfy is taking out of possession. So a movable property is in possession of a person who is having control or ownership over the property, just like an owner. So it need not be an owner, but anyone who is having control or authority over a property will be considered as a possessor of the property. So even if it's a bailee or even if it's a person to whom you have given your movable properties, that person also can file a case for theft. Like take for example, you wanted to repair your laptop and with that purpose you have given it to a dealer. And from the dealer, if I try to move your laptop with a bad intention, then in that case the dealer can also file a case against me for the offense of theft. Now dealer was not owner of the property, but he was having possession of the property. So dealer can also file a case against me. Fourthly, without consent, that yes, I should move the movable property out of possession of the possessor, but it should be without consent of the person. Alright, so whoever is having possession of the property, that person should not give his consent ki okay fine, you can move this property or you can carry it along or something like that. Alright, without the person's consent I should move the property. And fifth and the last one is physical movement of the property. So it's very important that I move the property from one place to another. It's not necessary that I should carry the property along with me right at that moment only. Otherwise it would not constitute theft or something. Take for example, I went to a friend's house and I saw that there was a gold ring lying on the table. If I have a dishonest intention of carrying that gold ring, but I feel that maybe the person would come to know about it if I take it right now only. So what I do is I keep it somewhere inside his house only, but I keep the ring somewhere where it's like nearly impossible for my friend to find it. And I have a bad intention that next time when I visit my friend's house, I will carry the ring along with me. Alright, so in that case also I will be guilty of theft. Why? Because I had a dishonest intention. With that intention, I moved the ring, right, from one place to another. I kept it somewhere so that my friend will not find it and later on I can carry it along with me. Alright, so in that case also I will be guilty of theft. So these ingredients you will come to know once you read section 378. Alright, definition of the term theft or what is it that will constitute theft. Now with regard to punishment, it is mentioned under section 379 of IPC. What is the punishment for the offense of theft? The maximum punishment that may be given is up to 3 years of imprisonment or fine or with both. That means both imprisonment also along with fine. Alright, so it becomes very important that you try to understand whether it is with fine or with fine or is it like with fine, right? Sometimes you would see that punishment is 3 years of imprisonment and fine. So whether it's and fine or whether it's 3 years of imprisonment or fine, that means it may be simple fine also. Alright, so what is the punishment for the offense of theft? It's mentioned under section 379 of IPC, and it is maximum of 3 years of imprisonment or fine, or both. That means both fine as well as imprisonment also may be the punishment. So these were the basic points which are very important, and even if it's a question for 6 marks, you should try to write all of these things. Now there are few other provisions which also you can consider writing if it's a question for 16 mark or something like that. These are basically nothing but aggravated form of theft. Alright, when punishment would also be greater and where severity of the offense is also more. So we basically have 3 more provisions with regard to 3 aggravated forms of theft. It's very simple if you try to read this part. Like I have just narrowed down the punishment because anyways if you read the provision it's very clear, right? Theft in a dwelling house, we obviously know what it is. You just need to focus on the punishment so that you can explain it in your own words, and then you can mention the punishment. So the first provision which we have is theft in dwelling house, and it is mentioned under section 380 of IPC. What is the punishment for theft in a dwelling house? It is maximum of 7 years of imprisonment plus fine. That means imprisonment will be there only. It will not be simple fine which is given as a punishment. Alright, so the punishment which may be given is maximum 7 years of imprisonment plus fine or along with fine. Now second type of aggravated form of theft is theft by clerk or servant of property in possession of master. This is mentioned under section 381, and punishment again is same, maximum of 7 years of imprisonment plus fine. Alright, so these two are same, only punishment would be same, theft in dwelling house and theft by clerk or servant. Now the last provision or the last section that we have with regard to theft is section 382. What is this provision? It is theft after making preparation for causing death, hurt or restraint in order to committing the theft. And here the provision is section 382. Now what is the punishment for this offense? It can be rigorous imprisonment for up to 10 years plus fine. Alright, so these are the 3 different aggravated forms of theft where punishments also would be greater as compared to normal theft that we have under section 379. So you can consider remembering the punishments at least, if not the sections, and then you can accordingly explain maybe in 1 or 2 sentences each of these provisions, and you can mention that these are aggravated forms of theft. Now once we are done with all the provisions, definition and then punishment and everything, you can proceed with a conclusion. It's very important that we end our question with a proper conclusion to the topic. Alright, so in conclusion, what can we write? We can write that property is considered to be an extension of personality of an individual. So IPC very well mentions with regard to different types of crimes that may be committed against property, as well as provides for sufficient punishment for each of those different types of crimes. And all these different types of offenses which we have under this chapter called offenses against property, they differ from one another based on what is the property involved, how the offense is being committed, or what is the severity of that particular crime. Alright, and accordingly different punishments are given and different names of the crime is also being given. So being a law student, it becomes very important for us to know the differences between all these different types of crimes which may be committed against property. So that's all for this question. I hope you are very clear with what all things you need to write for this answer. If you have any confusions or any video suggestions, you can leave that in the comment section below. I will see you next time with another video on IPC or some other topic. Until then, bye-bye.